Court of Appeals Division 1 is now in session.
Please be seated. Thank you all for being here. Today we're hearing 1CA SA13-0239, and that's Arizona Clean Elections Commission versus the Honorable Mark Bray. Each side will have 20 minutes to argue, and the appellant may save time for a rebuttal. Counselor, you'll have to manage your own time, and the clock is, of course, located on the podium. We are recording this argument both in audio and video, and the video recording is live. It'll be on YouTube at some point in the near future. We've read the briefs and we've conferenced the case. We understand the facts and the issues. So, counsel, if you wish to begin, you may.
Good afternoon. May it please the court, my name is Joseph Canefield. I'm here on behalf of the petitioners. The issue in this case is whether the legislature violated the Voter Protection Act when it enacted House Bill 2593 early this year and substantially increased the campaign contribution limits for statewide and legislative candidates. The court below erred in denying the preliminary injunction sought by the petitioners to prevent this law from going into effect and to preserve the status quo. The Citizens Clean Elections Act is covered by the Voter Protection Act, and by enacting 16941B, the voters set contribution limits subject only to biannual inflationary adjustments by the Secretary of State. Consequently, the legislature cannot change those limits unless it complies with the Voter Protection Act.
Counsel, how is the increase in the contribution limits inconsistent with the Clean Elections Act?
Your Honor, the question is, what did the voters intend to do when they drafted 16941B? And we think it's pretty clear. If you just look at the text of that statute first, you can see what they were trying to do, and that was they were trying to set the limits. And there's four parts of that statute that we draw your attention to. And the first is the fact that the voters put in the language, notwithstanding any law to the contrary. They wished for this statute to stand on its own. They also said that a non-participating candidate shall not accept contributions in excess of an amount that is 20% less than the limit specified in 16905. So by using the word specify, they were clearly referring to those limits in 905 as they existed in 1998. They also said that the limits could only be adjusted by the Secretary of State for inflation, and they put that language in 941B because they wanted it to stand alone. It was duplicative of other, there was similar language in 16905 that requires the Secretary to biannually adjust it. So they didn't need to put that in there unless they intended for that statute to stand on its own. And finally, they made that statute, a violation of that statute, a penalty in and of itself. And the last sentence in that subsection B says that any violation of this subsection shall be subject to civil penalties as specified in that section. So the voters were clear. They did not wish to simply reference the limits that would therefore allow the legislature to make any adjustments that it wished without acknowledging the effect that that would have on 16941B. And beyond that, Your Honor, if it's necessary to look beyond the clear language of the statute, we can see that the intent clearly was to set the limits in the Act. I mean, we know that from the 16940, the very first statute in the Clean Elections Act, sets forth the findings and declarations of the people of Arizona. And you can see that they were very concerned with the fact that the elected officials and candidates could take large contributions. So they obviously wanted to set the limits in the Act. The publicity pamphlet that this court will often look to, and when it attempts to ascertain voter intent, contains similar language. And then most importantly is the ballot language itself. That's the language that every voter read before they cast their ballot for or against the Clean Elections Act. And that clearly said that one of the main purposes of the Act was to lower the contribution limits for non-participating candidates. So we think that that statute, standing on its own, very clearly set the limits. And then therefore, under the Voter Protection Act, you have to ask the question, when the legislature substantially increased the contribution limits, and in the case of the aggregate caps, outright repealed them, did that impact or have some effect on the Clean Elections Act? And it clearly does, under the line of cases that we now are very fortunate to have from this court, as well as the Arizona Supreme Court, that sets forth the framework and the analysis that we must undertake when we ask the question of, does a change to a statute made by the legislature impact a voter-protected statute?
Before we get to the VPA, the Voter Protection Act, and at the risk of boring the audience, let me ask a little more basic question. You have raised in the petition a slightly different argument, which you've called the statutory construction argument. And I would like, it would be important, it's important for me to understand precisely which horse you want to ride. I guess you want to ride both of them, but let's talk about which is the lead horse for a moment, okay? So, the argument as I understand it is that we don't even have to address the Voter Protection Act, because we can look at the language of 16941, that's the provision you've just been discussing, Mr. Canfield, and we can look at that provision and say, okay, because it says notwithstanding any other law to the contrary, it means then that House Bill, forgive me, I always get the terminology a little confused here, but the House Bill 2593 is just never became effective. So is that the argument you want us to decide this case on, or is that just an alternative argument, or how is that different from the VPA argument? Because they seem to me they're quite similar.
They're all alternative arguments, Your Honor, so maybe we should discuss that argument, because under the constitutional avoidance doctrine, I suppose that would be the easiest way for this court to decide this case without having to necessarily strike down an act of the Arizona legislature. And what that argument says is that 16941B, under the doctrine of specific reference, by referencing 16905, the contribution limit statute, back in 1998, it incorporated that statute into 941B as it existed in 1998. And therefore, any subsequent changes to the contribution limits in 905 would not have any impact on how the manner in which they were incorporated into 941B.
Let me stop you for a second, but isn't that doctrine also part and parcel of the argument that the VPA, or rather House Bill 2593, is ineffective or unconstitutional because it violates the VPA? Both of those arguments share a common kernel, it seems to me, which is, what does the Section 16941B mean? Because if it doesn't mean what you say it means, then House Bill 2593 wins, either under the Voter Protection Act or just under principles of statutory construction. So isn't that a common issue for both?
I suppose it's a common issue in the sense that it helps provide some meaning to 16941B, or at least explains what the voters were trying to do, and that under either argument, the voters were trying to set the limits. You know, either whether they were incorporating them into 941B and 941B standing on its own, or whether they were just preventing the legislature from making changes to the limits for statewide and legislative candidates without a three-quarter vote as required by the Voter Protection Act. So either way, we think that informs this court as to what the voters were trying to do with 941. And we agree, Your Honor, that's the very first issue that has to be resolved, which is what were they trying to do in 16941B? They certainly weren't trying to just create an arithmetic formula that the legislature could just circumvent by setting the limits at 125% of whatever they wanted them to be. I mean, that clearly doesn't square with the intent and the declarations of the voters who are very clearly concerned about contribution limits when they enacted the Clean Elections Act. And so it would be it would have been quite astonishing if the legislature, the day after the Clean Elections Act passed, simply removed the limits or raised them back up substantially, or even raised them back to where they were before the Clean Elections Act. So we think that is important to take into consideration. Again, that our argument's based, on the text, clear language of the statute itself, as well as what the intent of the voters, what they were trying to do. So, the other thing I'll mention, Your Honor, is the real parties in interest have raised an affirmative defense, and they're basically, as we understand it, arguing that the legislature had to do what it did. And this, to us, this isn't acknowledging that what the legislature did, in fact, violated the Voter Protection Act. But they're saying that the limits that were in place prior to House Bill 2593 were unconstitutionally low, and therefore they had to take steps to bring those limits within the range of constitutionality. And we don't think that that's a valid defense, and we don't think that it's a defense that the court should take into consideration, because, for one, there was never any kind of challenge to the limits as they were in 2593 prior to the legislature passing House Bill 2593. So what this really amounts to is a finding by the legislature itself, or at least certain legislators in this case, because there was never a formal finding by the body as a whole that the limits before were unconstitutional. And if you take it logically to the next step, what you really have is the legislature saying that if we determine as a body or individual legislators that the limits or the law that is voter protected has constitutional issues, then we can take steps to change that law to bring it back in, to make it constitutional without a three-quarter vote.
Well, let me ask you a question. Let's suppose hypothetically at this point we agree with you that either under the VPA or under principles of statutory construction that House Bill 2593 is ineffective. And so we send this back to the trial court. At that point, isn't the First Amendment or the free speech, aren't the free speech issues in this case, and don't they need to be addressed by the trial court? Because then there is a determination that the limits in the Clean Election Act are effective or remain effective. And so shouldn't the Speaker and the President be given an opportunity to challenge those limits, and what's wrong with your lawsuit? They
certainly have a right to challenge those limits in a separate proceeding or perhaps as a counterclaim, but not as an affirmative defense, because they couldn't get the relief that they wanted as an affirmative defense.
Well,
they couldn't get
an affirmative defense. The court is, I think it's Rule 8 or something, is freely at liberty to change the nomenclature and to square the pleadings away to fit the facts in the law, so it could easily treat the affirmative defense as a counterclaim or a cross-claim.
Well, perhaps, Your Honor. But then that gets back to the point I made earlier, which is that it doesn't excuse compliance with the Voter Protection Act. The Voter Protection Act is in Article 4 of the Arizona Constitution. It governs the proceedings of the Arizona legislature.
But isn't that why you're here? We're going to tell you what that is? We're going to decide that issue, you think?
But we're here because we think that the House Bill 2593 is unconstitutional. They're saying that the limits before were unconstitutional. Well, they can bring their own lawsuit to make that determination. We think that the only issue before the court is, does House Bill 2593 violate the Voter Protection Act? And if their concern was about the First Amendment issues associated with the limits before then, well, then that can be addressed separately, but that doesn't help save them from the violation that took place when they passed 2593 without a three-quarter majority. And in terms of the defense, John, we're perfectly willing and able to talk about that substantively if that's where the court wishes to go. I mean, we've fully briefed it. We don't think it's a valid defense. So I'm sorry, Your Honor.
So what would the effect be on 941B if under whatever analysis the limits in 905 would be found to violate the First Amendment.
Well, then it would be like any other statute that had been declared to be unconstitutional. So it would be unenforceable, and at that point, the legislature would have to, could take measures to bring it back within the scope of constitutionality. With contribution limits, it's deciding contribution limits are constitutional. It's just a question of how low can they be. So if the court were to strike down the limits as being too low, which again, we think under the Randall v. Sorrell case, that argument fails on its face, but setting that aside for a moment, well, then the legislature could take steps to bring the statute within to the zone of constitutionality, but it would have to do so in compliance with the Voter Protection Act. The Voter Protection Act does not have an exception that empowers the legislature to disregard its provisions because of an underlying either concern by the body itself about the constitutionality of the law or as a result of a court order. So,
yeah, Mr. Kingfield, so if I understand you correctly, and I could be wrong, but is it your position that in order to raise the limits, the contribution limits, that there has to be a finding by somebody, either a court or the legislature themselves have to make a finding that those limits are unconstitutionally low before they can, or they have to comply with the Border Protection Act? Is that
the latter, Your Honor? We disagree that there has to be any finding. I mean, there may be, say that there was a separate lawsuit, and there could have been. I mean, there has never been a challenge before House Bill 2593 to those limits. So say there had been a challenge, and then a court struck it down. Well, then the legislature could respond, but they still have to comply with the Voter Protection Act. So whether it's in response to a court order, or it's in response to concern by staff attorneys or by people testifying at the legislature or the legislators themselves, they don't get excused from complying with the Voter Protection Act. So, and they can do it. They've done it before. They did it in 2007. They can respond to a judicial ruling with a 3/4 vote. It's certainly possible. I think it's what the voters envision when they put the Voter Protection Act into the Constitution, and the legislature has to live with the rules that govern its proceedings. With that, I'd like to reserve some time for Your Honor.
I don't want to. It's just a hypothetical, and it doesn't mean much with his case, so let it go.
Thank you, counsel.
May it please the court, and good afternoon. I'm Michael Liberti with the firm of Snell and Wilmer on behalf of the legislative interveners, the Honorable Andy Biggs and the Honorable Andy Tobin. Just so that the court knows, David Weinswag is here on behalf of the Secretary of State. Mr. Weinswag has agreed to allow me to the full 20 minutes of time.
Actually, I have some questions I would like to ask him, so do you mind giving him back a couple of minutes?
No, Your Honor,
Okay.
that's perfectly acceptable.
Okay.
Thank you. This case is about whether the Voter Protection Act extends its protection to cross-reference statutes in ballot measures, and further whether it extends the protection to statutes that wouldn't otherwise be entitled to receive voter protection. Specifically here, the petitioners claim that Section 16-905, which was enacted in 1986, is somehow subject to the Voter Protection Act.
Well, but counsel, if we agree with petitioner's argument on circular construction, we don't really get to the VPA argument. Is that correct?
Well, I think you could get to it, but then you have a problem to deal with. First of all, I don't think that the court gets to it because the petitioners waived that argument. It is not in their complaint. They're seeking declaratory judgment based on the Voter Protection Act only. It wasn't an issue before the trial court. They made a passing reference to it in their reply to the motion for preliminary injunction, and they've waived it.
Well, but counsel, let's assume for the moment that it hasn't been waived. what would your answer be then?
Well, then, Your Honor, I think that the petitioners are dealing with a big constitutional problem that has its genesis in Article 4, Part 2, Section 14 of the Arizona Constitution. That section says that you cannot amend a legislation without setting the text of that legislation out in full. And that provision applies to the voters through Article 22, Section 14, I believe it is. And if I'm misrepresenting the statute, forgive me, it's in our briefs. But that provision applies to the voters. So, and essentially this is the way. But
isn't there a problem with that point? And the fundamental point is the Clean Elections Act did not amend 16905. It didn't even purport to do that. It, at best, incorporated by reference or adopted limits in 905, but it didn't amend 905, so that section of the Constitution, assuming it applies to the voters, and you make a convincing argument on that point, it's inapplicable here because the Clean Election Statute did not amend 16905.
Well, Your Honor, we respectfully disagree on 2 points. Number one is we don't think we get to that argument, but number two is the constitutional provision says that you can't make an amendment to the law without setting forth the law in full.
But if you're not amending the law, it is inapplicable. One has to amend for that to be in play.
But then, Your Honor, you're in a situation where the voters are being told that certain contribution limits are going to be in place, and they're not even shown what those limits are.
That's a different issue. Let's stay with your constitutional argument. The point you're making is that 16941 amends 16905. I don't see any amending language. What I see at best is it's like the Clean Election Statute is here. It takes from over here. It's like taking from Peter to pay Paul. And so it goes backwards, but I don't see an amendment.
Well, Your Honor, let's look at it from a different side of that coin. Perhaps then 941 didn't amend 905.
Okay.
But then perhaps 941 is an amendment in and of itself in 1998 when it was proposed to the electorate as a new law. That itself is the amendment. And it's making an amendment to existing law by cross-referencing something that exists in another piece of legislation that the voters were not even shown. Now, the petitioners in their reply brief say something about a case called Clean Elections versus Myers, where all the electorate needs is to have some title and some text. Well, I think they're misreading that case. The Myers case looked at whether you could save an initiative because it didn't have a title, so you went down 3 lines. But what the some text means is it has to have law that enacts something. It can't enact a general principle. It can't enact some sort of a general point of law. It has to have some text that gives the initiative meaning. So for those reasons, we don't think that their incorporation by reference argument works. Now, if that is their argument, and I'll talk perhaps about your concern, Judge Norris, but also a more broad concern about why this is bad public policy for the state of Arizona, is that if this court were to come down with a rule that an initiative drafter, all they have to do in order to invoke VPA protection is cite a cross-reference to a statute, maybe use that in some way in the act, and therefore you've just invoked VPA protection, you are then going to create, as Judge Brain referred to it, as havoc in the legislative process.
Let's not go down to game theory here. Let's go back to your argument. And let's put the VPA aside. If the Clean Elections Act adopted, and not amended, but adopted the limits specified in 16905, the constitutional provision you noted is inapplicable. The VPA we don't really need to address because 16941 begins with the words notwithstanding any other law to the contrary. So doesn't it trump?
No, it doesn't, and I'll offer an explanation what that notwithstanding any other law to the contrary means. What that means is that there isn't supposed to be some other fund that a candidate could draw off of, a traditional candidate, for electioneering reasons to get around whatever the limits are. And in the federal system, sometimes you see those as recount funds or constituent services funds or litigation funds. And the way we view that is that the clean elections drafters intended there to be one source, one campaign account for candidates to use to run their campaigns on. And that campaign account is going to be funded by contributions based on the numbers. But and by the way, this is what the Act says. In 941B says an amount. It will be an amount based on what is in 905 reduced by 20% plus inflation. And that's what it means, is you've got to look at that formula, and you can't have some other statute to the contrary. Now, kind of playing off that argument is this. Up until a few months ago, the Clean Elections Commission has viewed Section 905 as the operative first variable in that formula. They did it in 2007 when there was a consensus bill that was passed in the legislature to enact new contribution limits. That bill received a 3/4 vote because it needed to. It increased participating candidate payouts, but it also increased the traditional candidate contribution limits. And this is cited in our appendix, and you will see that the bill that the Clean Elections Commission supported did not impose a VPA requirement on Section 905. Now I ask the question, number one, if the Clean Elections folks intended to enshrine the 1998 contribution limits in law, why didn't they do it in Section 941 as a hard and fast number? Why, in 2007, when there was a consensus bill, didn't the Clean Elections lobby amend Section 941 to put hard and fast limits in that statute? Why, when the Clean Elections Commission was lobbying their bill of their own, House Bill 2575, did they use Section 905 as the jump-off point for the first variable in the formula and not amend Section 941? The Clean Elections Act, the Clean Elections people for 15 years have treated Section 905 as that starting point. Now, we've heard a lot from opposing counsel about what the voters intended.
But I have the 2007 amendment right here, and it appears to me that Chapter 277, House Bill 2690, also made some changes to 16941.
You're correct, Your Honor, but it was part of a comprehensive scheme that was a consensus bill between the Clean Elections Commission and other interest groups, in which they amended as a somewhat of an omnibus bill. And if you look at the end, I believe it's Section 14 of the session law, that section will say that pursuant to Proposition 105, certain provisions of the Act are being passed with a 3/4 vote and a furthering the purpose, yet other sections are not.
Boy, you know, I look at Section 12 of the same bill, and it lists 16905, 16941 with legislative declaration furthering the purpose. I see that in Section 12. I see a reference in Section 13 to 16941.
Your Honor, if I may check my record.
And I see a section of reference to 16941 in Section 14.
Your Honor, this is our appendix, IA 146, Section 14. Pursuant to Article 4, Part 1, Section 1, Constitution of Arizona, Section 16-941, 16-950, 16-952, 16-953, so on and so forth, as amended by this Act, are effective only on the affirmative vote of at least 3/4 of the members of the House and the legislature.
I'm sorry, I see Section 12 that I can read it to you as well. The legislature hereby finds and declares that the provisions of this act, that's the entire act, further to the purposes of the Citizens Clean Elections Act, adopted by 1998 Proposition 200, and enacted into law, and it goes on. So, I mean, there's plenty of language in the 2007 statute to suggest that the legislature was attempting to comply with VPA.
Well, Your Honor, respectfully, what it says is Title 16, Chapter 6, Article 2 is the Clean Elections Act. Section 905 is in Article 1 of that. So, I mean, I just respectfully disagree with that. The Supreme Court's decision in Cave Creek versus Ducey that was handed down 2 weeks ago set forth the test. And that test starts with the proposition that the court will presume acts of the legislature constitutional. And it is the petitioner's burden to show that there is a VPA violation. The court also said that the test looks at whether there's an implied amendment. And it will find an implied amendment if, after construing both acts as best as they could, there's no way to harmoniously construe them together. Now here, the way that the Clean Elections Commission or the Clean Elections drafters intended it was to have an amount in Section 905, and whatever that amount is, that it be reduced by 20%.
Well, because how is that consistent with all of the history of the act about there's too much money in the system, the fear of corruption? How does that square?
Your Honor, the Clean Elections Act was enacted with the purpose of leveling the playing field. And it's now that the clean elections folks have pivoted since the 2011 decision by the U.S. Supreme Court to try to grasp onto the anti-corruptive efforts. The Clean Elections Commission has never had authority to enforce traditional campaign contribution limits. It's in Section 16-941B. The last sentence says that the campaign contribution limits that are applicable to traditional candidates will be enforced by the Secretary of State and the Attorney General. They've never had that authority. And if you look beyond that, as circumstances have changed, the corruption and the appearance of corruption issues are no longer served by such drastically low contribution limits. When courts talk about corruption and the appearance of corruption, you need to go on to really figure out are these narrowly tailored. So we don't think that there's any corruption problem by bringing Arizona into what essentially is the bottom of the median of all states in the United States in terms of campaign contributions. And the clean elections petitioners have provided us with no evidence whatsoever that there is any corruption risk with these limits. In fact, their own expert in his declaration says trying to prove corruption is a speculative task, less grounded in data than other types of analyses. So they haven't been able to show that there's a corruption purpose. Now, I just want to end on this because, Your Honor, I know you have questions for my colleague. But I do want to say this, that the preliminary injunction standard requires a likelihood of success on the merits, possibility of irreparable harm, balance of hardships tips in their favor, and public policy. The other side has not met any one of those tests.
How can we know that? I mean, I'm serious. How can we know that? The Arizona Rules of Civil Procedure absolutely require a trial judge who either grants or denies a preliminary injunction to make findings of fact. There are no findings of fact in this order regarding those elements vis-a-vis the First Amendment. So how can we know what the judge found?
Well, I think, Your Honor, you have to look at the record.
But we are an appellate court. Trial judges are obligated. Our Supreme Court has said it's their legal duty to make findings of fact, and we have none here.
Well, I believe that the trial judge referenced what was pled in the parties' papers. So if you're willing to look at the record, I think what you would see is you have 4 petitioners who have tenuous standing, very problematic standing problems. You have one petitioner who claims that who is a traditional candidate who claims that she might run as a clean candidate.
Now, I asked, forgive me, sir, I asked you about the lack of findings of fact. I'm not asking about standing, which is a completely separate issue that the judge addressed in a separate order, which is not part of this special action. So let's stay with my question about the lack of findings. How do we, as an appellate court, decide what this trial judge decided vis-a-vis the First Amendment issues presented when he didn't make any findings at all?
Your Honor, I think that that there are multiple ways to deal with that, but I don't think one way to deal with that is to reverse the order denying the preliminary injunction and then instate the preliminary injunction. Perhaps one way to deal with that is to remand to the judge to make specific findings with respect to both sides' argument. But I don't think that that warrants this court reversing and then awarding the preliminary injunction based on what it perceives to be a lack of factual findings. So I'd be happy to answer other questions, but I do want to give Mr. Weinswag time.
Yes, thank you, counsel.
Thank you.
Your Honor, David Weinswag, on behalf of the Secretary, and I'm happy to field any questions you might have.
Well, I just wanted to make sure you had a speaking role today. It doesn't seem fair to leave the Secretary. No, seriously. My question is this. Let's say that we agree with the petitioners here, and we decide that we're going to remand this back to the Superior Court for additional findings. But in the interim, because of the unusual nature of this case, we would normally direct the Superior Court to enter a preliminary injunction. Do we need to do that? My specific question is, well, if we declare or decide that 16941, the Clean Elections Act statute provision that's at issue here, remains effective and has not been preempted or amended by House Bill 2593, is the Secretary of State going to then continue implementing and enforcing House Bill 2593, or is it going to comply with the decision of this court so a preliminary injunction would not be necessary pending further work in the Superior Court?
Your Honor, the Secretary is only concerned with what the law is. And you had an amendment that was that the legislature passed that brought some uncertainty to the equation. So my answer to you would be, whatever your direction, whatever your opinion says, the Secretary will comply with whatever the directive is. Now, whether you have to go an additional step beyond finding, so the initial step saying that the petitioners are correct and that this legislation either violates the VPA or remains in effect, I would think that in and of itself is direction that the Secretary can and would comply with. That there doesn't necessarily have to be an additional sentence saying, and we're remanding, and in the interim, the Secretary is not to, and then, that said, I think a lawyer's job is always to mitigate risk, and direction is always preferable to direction that might require some thought. But I think what you're saying is, I would agree, which is that the Secretary should be able to take an opinion and act based on that opinion without another sentence that is directing some stay.
Thank you, counsel. Mr. Plainfield.
Thank you, Your Honor. I know my time is limited, so I will address the points that I think are necessary and answer any questions you may have. On the cross-reference issue, I would direct the Court to pages 8, 9, and 10 of our reply brief. We think we've adequately briefed this question, that the cross-reference provision in the Arizona Constitution that my colleague refers to in Article 4, Part 2, Section 14, does not apply to citizens' initiative. That's very clear from the case law. So whatever prohibition it would have, and we don't think it would necessarily, even if it did apply, it doesn't apply here. Part 1 of Article 4 is the citizen initiative provisions. Part 2 is the provisions that govern the legislative process, the proceedings of the legislature itself. We did not waive that argument. We clearly made it below. We cite it in the pages I mentioned, 8 through 10. We are not arguing, and the issue in this case is not whether a reference statute in a voter-protected statute becomes cloaked with voter protection itself. That is not the issue before the case, no matter how hard the real parties in interest try to frame that issue that way. The question always is going to revert back to the voter protection analysis that we have in the Cave Creek v. Ducey cases and the early childhood development case, where we have